Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-3083, United States of America versus Wayne Holroyd, appellants. Ms. Ernest for the appellant, Mr. Burney for the appellate.
Ms. Ernst, good morning.
Good morning, Your Honor. Good morning, Your Honors, and may it please the court. My name is Robin Ernest, and I represent appellant Wayne Holroyd in this appeal. Congress,
Can you get closer to those microphones? And you have a very soft voice.
Okay. Thank you so much. Congress did not write or, it wrote and into the plain text of the safety valve statute as amended by a bipartisan First Step Act. Consequently, this court should decline appellee's request to read an unwritten or into the statute now for three reasons. First, the plain text. Second, its structure as a conjunctive negative proof. And three, its compliance with the Senate legislative drafting manual. All support one plausible reading, and that is that it is conjunctive. Or, as the Ninth Circuit stated in Lopez, that and means and.
Yeah, and then how do you address Judge Colleton's, what I think, impeccable decision in the Eighth Circuit in Pulsivar? I mean, I think that is exactly right insofar as the reading on the other side. And to be very honest with you, from my perspective, it's a compelling reading of the statute. And I think that this argument over and is completely misguided. There are three requirements that have to all be met. And I think that's exactly what the words say. And I was shocked that anyone thought otherwise. And I don't mean to suggest I know it all. I was just shocked that there was another reading. And so, you know, I put that on the table. You can answer it as you see fit. My view right now, having prepared very carefully for this case, is Judge Colleton's position is correct. Why do you think it's wrong?
Your Honor, respectfully, the Eighth Circuit found in Pulsivar that it adopted a distributive reading only after finding that there was surplusage. Only after finding that when you would have subsections B and C met, that you would automatically have subsection A met also. Pointing to the opinions by Judge Wood in the Seventh Circuit and by the majority opinion in Lopez, they provide two compatible reasons why we feel that that is not true, that there is no subsection. First, linguistically, the language in subsection A is different from that in B and C. Subsection A counts criminal history points, which the guidelines identify as being prior crimes, prior sentences, which are not older than 15 years for 3-point offenses and 10 years for 2-point offenses. In that regard, they are distinct under the guidelines from B and C, which only address prior offenses. And since each of the criteria in A, B, and C are qualified by the clause as determined under the guidelines, they must be read with the guidelines. The guidelines chapter 4, specifically 4A1.1, is controlling on determining criminal history points. The commentary in 4A1.1 is clear that point 1 and point 2 must be read together.
Mr. Ernst,
yes,
I take you to be referring to the distinction that Judge Wood, in her opinion, in dissent in the Seventh Circuit, makes this argument. But it seems to rest on a kind of a function of prior offenses or a description of prior offenses that's unrooted to their role, which is in understanding history. So it seems to like create an understanding of a prior offense that is novel. Is that wrong?
The term prior offense is not identified in Chapter 4 of the guidelines, 4A1.1. The 4A1.1 only talks about counting prior sentences. And so that's why it has to be read in conjunction with point 2. So the linguistic distinction is very important because it's consistent with what courts currently do and probation officers currently do in counting criminal history points, not prior offenses, in determining a defendant's guideline range. And therefore, the linguistic distinction in A, since it only counts prior sentences less than 15 years, is different than what's in B and C. And so we feel that A, by its structure, addresses more recent criminal sentences, and B and C still allow the court to consider older criminal offenses, criminal sentences, in a sense of considering whether or not there has been recidivism in relation specifically to B, and in C also allows the court to consider misdemeanors that they feel are compelling in relation to the fact that they might evidence some factor of violence. And of course, violent offenses, as used in the guidelines, include both violence against persons and property. So it would include vandalism, for example. Under the government's interpretation, you would not want someone to be excluded from relief from mandatory minimums who simply had a misdemeanor offense for vandalism. That would be under C. So that makes the cumulative reading, which was advanced by the court in Lopez for the Ninth Circuit, and also adopted by Judge Wood in her dissent in the Seventh Circuit, the more reasonable, the more plausible one. Also, it's consistent with the canons of statutory interpretation, which require us to read and as and. And so reading and as conjunctive, as someone who would be reading this plain text for the first time would, then they would feel, as Holroyd felt, that he had to qualify for all three of the criteria listed in A, B, and C in order to disqualify for the safety valve consideration.
Ms. Ernest, is your claim, I take it your claim is limited to an ineffective assistance of counsel claim. There's some suggestion in your brief, but then when the government calls it out, you don't take it up in the reply brief. There's some suggestion that you were making a direct argument that the appeal waiver did not cover the First Step Act because the First Step Act was enacted after. I take it you were not making that argument.
That's correct, Your Honor. Our argument rests upon the allowance in the appeal waiver to bring ineffective assistance of counsel claim, and that's what's being done here, but it rests upon the merits. So there needs to be a determination as to whether or not the reading, or the conjunctive reading, was the one that counsel should have been put forth at the time of sentencing. And
so you believe we do need to reach the merits and decide that issue. We can't just say that's colorable and remand to the district court who, for example, might say whatever reading, I would impose the same sentence anyway. That's not you're not asking us to simply remand without deciding the merits of the statutory question.
We believe that that Holroyd's appeal raises a textual question as was done before this court in Winstead, and then as this court did in Winstead, that you would need to reach the merits of that textual claim in order to determine whether or not there was ineffective assistance. In other words, in order to determine whether or not this was a reading that was so plain that in sentencing, the defense counsel should have taken it on his client's behalf. And we rely upon Winstead and also in Hawthorne for the argument that a beneficial sentencing argument should be put forth at the sentencing proceeding because of the finality of those proceedings. And in that sense, it is different from U.S. versus Glover, which the government relies upon. But if I can get back to clarifying surplusage, and again, the Eighth Circuit's decision, they only reached the distributive reading once they found that there was, one, a conjunctive reading, and also that that conjunctive reading yielded impermissible surplusage. Of course, the canon of surplusage is simply a statutory canon. It should not override the weight of the plain text, which we believe is conjunctive, as the Ninth Circuit found in Lopez. I see that my time is up. If there are other questions, otherwise, I will reserve the rest of my time for rebuttal.
Okay.
Thank you.
Mr. Burney?
Thank you, Your Honors. May it please the Court, Kevin Burney for the United States.
Can I ask you first, the
Sure.
way I read 3553F1 is someone with two-point nonviolent offenses or less qualifies. Other than that, no. You don't count 1 point.
That's right. You don't count 1 point. So if
3
somebody
point.
only had a 1 point conviction,
Right.
they're $50.
And two-point nonviolent would still be within the not more than 4,
Correct.
and you would not have the 3 point.
Correct.
Can you think of another combination?
Well, obviously, a 1 and a 2, a 2-point nonviolence.
Well, or
and a
less.
1,
Yeah,
right,
or
would
less.
also count. But yes, I think those are the only permutations I can think of at the moment. But I think that's actually a good point, Your Honor, because obviously a lot of this discussion is revolving around absurdity and how to read this statute in context. So, for example, let's say that we had a defendant with 2 drug distribution convictions for which they served 1 year in prison on each conviction. That's pretty serious. That would be, in almost all cases, 2 felony drug distribution convictions. They are still eligible for the safety valve under our reading. And that is the modest expansion of the safety valve that Senator Leahy and Senator Grassley were indicating in the legislative history when Congress passed.
Well, really, we don't know. I mean, they talk about modest, but they also say this is, on the way to correcting the problem with over-incarceration based on nonviolent drug offenses. And so the text is really what we have to contend with. And I have to say, when I read this, I thought, and this, and this. If you have these 3 things, that's what disqualifies you. I mean, that's the way we use the language, and that's the way the Senate drafting manual uses the language. So one has to conclude that they meant something else, and that we're willing as a court to redraft the statute to fix it.
Well, I think there are 2 possible readings of the statute. I think there's the statute, the reading that Your Honor posits, in which it is used as conjunctive cumulative, and that's how Lopez read. But I think there is also the reading that we advocate for here, and that Pulsiver also adopts, and that the concurrence in Pace adopts. And honestly, the majority in Pace adopts a very similar reading. It uses the word disjunctive, but it comes out in the same way. So basically, Pace and Pulsiver are both using the and in a conjunctive distributive sense, which is another way that you can read the statute. And I think part of the complexity here is the fact that the prefatory phrase "not" that is in the prefatory phrase. And Scalia points out in his book that with negatives there are nuances. This is the type of nuance I think that we're talking about. One person could read it the way Your Honor has posited, but another person could very easily read it the way that we're positing. In fact, we think our reading is better. If you have these two competing readings, then you have to decide, okay, what did Congress mean? And that is where you have to look to context. We obviously make a number of arguments along those lines, not just the absurd results argument, which I can elaborate on, but also the superfluous argument. So appellant's reading of offense versus points in BNC is quite strained, we would submit. I mean, Pulsifer noted that the word offense in BNC is really just a common sense shorthand. How else was Congress supposed to refer to a prior conviction as an offense? The important word in BNC is point. Congress is saying 3-point offense, 2-point offense. And that is really what should be looked at. So these past convictions, which are not scored, which have no points, are not really relevant. That's not a reason to say that the candidate against superfluity doesn't apply here. One other thing that I just want to note before getting more into the merits of the issue, which of course I can respond to questions to, is that this is an ineffective assistance of counsel issue. It is not the merits, which is what Pulsifer and Lopez and Pace all had to deal with. Here, this court, frankly, I think has, I don't want to call it an easier burden, but a different inquiry to make. It is just whether counsel was so deficient, so constitutionally deficient for not making this argument, which we have, I think the briefing has already established, is not an obvious argument to make. And I would note, too, that at the time that counsel, at the time of Holroyd's sentencing, as far as we can tell, the argument had never been made in any court throughout the country. Even in Lopez, the district court had not yet received a sentencing memorandum from the defendant that made this argument. So just putting yourself in Mr. Zucker's, the defense counsel's shoes, at the time of this sentencing, the argument has never been made, apparently. It certainly has never been decided. He is looking at his client, who at this time, the PSR is indicating is a career offender, which is dramatically increasing his exposure. And so Mr. Zucker is focused at sentencing on that. And he writes a very persuasive sentencing memorandum for why he is not a career offender, which the district court agreed with.
What's the strategy in that situation of not also making a plain textual argument? I don't understand how that even could be a strategic decision. If you have a strong argument on career offender, this doesn't detract from that. It doesn't express any, failure to take responsibility. It just says, here's a new statute that is intended to give the district judges more discretion. It doesn't require anything of them. It gives them discretion if they think it's appropriate. Why wouldn't counsel make that argument? I don't understand the strategic characterization.
Well, I think there are two potential responses. First, just more directly on the strategic point that Your Honor is making. Mr. Zucker could have reasonably thought the career offender provision is really driving the inquiry here, and that's what I need to spend most of my time on. That's what I need to convince the court. And he is looking at, instead, an issue here, the safety valve, which nobody has ever brought up. And so why not, instead of, raising all of these issues for the district court and getting bogged down in that, instead just focus on the career offender approach and dramatically reduce his exposure. But then the second thing that I would say is that could he have made the argument? Of course, theoretically, any defense counsel can make any number of arguments, right? But the record indicates that he did not agree with the arguments. He said on the record he did not think Mr. Holroyd was correct. And by the way, we agree with that. We don't think Mr. Holroyd was correct. But that was a perfectly reasonable position for Mr. Zucker to take. And he does not have to make all the arguments that Mr. Holroyd wants him to make, of course. when you look at the record as a whole, Mr. Zucker did a pretty good job for his client. He brought down his exposure tremendously. At one point, Mr. Holroyd was talking about withdrawing his plea. The district court noted that if he had been convicted of one of the substantive drug offenses, he would have been a career offender if that had happened at trial. So Mr. Zucker is coming in here and actually, we would submit, doing a pretty good job, far from being ineffective.
And at least a couple of circuits, it turns out, agree with him.
I'm sorry, Your Honor?
At least a couple of circuits agreed with him.
That's correct.
I mean, eventually.
That's right. Full sovereign case have now.
Do you have 3553 in front of you?
I do, Your Honor, yes.
Okay. First of all, I think the defendant agrees that all 5 have to be met, subdivisions, 1 through 5 of 35. So that's one definition, one usage of and. In other words, 1, 2, 3, and 4, 1, 2, 3, 4, and 5 all have to be met. Okay.
Correct.
Nobody talks about 4. And I'd like you to tell me what your reading is of the and in 4. In other words, to be eligible, you cannot be an organizer, leader, so on and so forth, and not engage in a CCE. How do you read that and?
Well, here I would read the and. I think everyone reads this and to say that, yes, he has to meet all 5 of these criteria to be safety valve eligible. But we would actually argue that the and in F1 that we've been talking about this whole time is consistent with that reading because we're arguing he has to meet all 3 of the criteria under F1.
Well, I'm asking about subsection 4.
Right.
So if you have been a leader and an organizer, but not in a CCE, do you qualify?
Let me just look at this very quickly, Your Honor, because I haven't considered this until now. Oh, I see. You're talking about the internal and. I understand. Hold on.
Yeah.
I think you would have to meet both of these requirements. You would have to show that you were not an organizer, etc. And it would have to be shown that the defendant was not engaged in a continuing criminal enterprise. That's my reading of it offhand. I have not looked at this issue though yet, Your Honor. Yes, I think both of those would have to be met. That's my first.
I think the CCE is surplusage because my clerk and I looked at this, and according to the CCE crime itself, you have to be a leader or a supervisor or a manager to be guilty of CCE. So that second requirement of not being engaged in a continuing criminal enterprise may be surplusage. But I just wondered if you looked at it and what your...
I had not, no. So I could not tell Your Honor one way or another, unfortunately.
Okay.
And doesn't that use of and underscore the difference between F4 and F1? Because to make F1 I'm not going to pull this off. It seems like to read F1 the way you are urging us to read it, C would have to begin does not have, as the clause following and says was not engaged. So if it said the defendant does not have A, more than 4, B, a prior 3, and does not have prior 2, that would make the negative distributive, but we don't have that distribution. And so you're injecting text. And I guess my question is, I understand the reading, I've read the cases, they do a very good job of it. Where are you on the rule of lenity? You really think it's so clear that there's no ambiguity to read this in favor of the defendant, make him eligible for something, give the district court the opportunity to consider it in light of that authority that he can or can decide against exercise.
Well, on the rule of lenity point, the standard there, as I've seen it in the case law and the other cases, has been a grievous ambiguity. There's grievous ambiguity. We would submit there is not a grievous ambiguity here because of all of the factors we pointed to: superfluousness, short results, legislative history, structure of the statute, etc. I think it's Pulsiver rejects the rule of lenity argument. It's either Pulsiver or Pace.
Pulsiver does.
Pulsiver does, yes. And so he uses the grievous ambiguity standard, I believe. And so we would submit that that is the right way to approach that.
Right. If there are no more questions, thank you.
All right. Thank you, Your Honor.
Let's see, Ms. Ernest, why don't you take 2 minutes?
I wanted to get back to the surplusage argument as it was addressed in
You want
Lopez.
to take your
Lopez,
wrap?
the
Yeah, thanks.
Lopez, the court addresses that by showing that when you have B and C met, you don't necessarily have A met. And that's because you can have a 3-point violent offense that satisfies both B and C, but is under the number of criminal history points that are required under A. And I will use an example to answer Judge Henderson's questions about instances when a defendant would not be eligible. He would not be eligible when the defendant had a 3-point recent violent offense and another 3-point nonviolent offense, because he would have 6 criminal history points. He would have under A, he would have a 3-point violent offense under B, and that would simultaneously satisfy as at least 2-point violent offense under C. Another example is a defendant who has a 3-point nonviolent offense and a 2-point violent offense. Then he would satisfy subsection A by having 5 criminal history points. He would satisfy B by having a 3-point prior nonviolent offense, and he would satisfy C by having a 2-point prior violent offense. All this is to illustrate that the safety valve, as employing the conjunctive interpretation that appellants are requesting here, does not have the absurd results that the government is arguing. It does not effectuate to release or to allow safety valve eligibility for serious violent offenders. And what safety valve eligibility does is only allows courts the discretion to sentence within the guidelines as usual. I see my time has expired.
All right, Ms. Ernest, you were appointed by our court to represent Mr. Holroyd, and you've done an outstanding job, and we thank you.
Thank you, Your Honors. Thank you.
Case number 21-1249, International Organization of Masters, Mates, and Pilots, ILA-AFL-CIO petitioner versus National Labor Relations Board. Ms. Danidovich for the petitioner, Ms. Isbell for the respondent, Ms. Cooper for the intervener.
Good morning.
Morning, Your Honor. Lisa Dominovich of Bush Gottlieb on behalf of the International Organization of Masters. May it please the court. There's 3 points in which I wish to make that are in the brief, but I think can be highlighted further. The first is that the 1981 agreement is a foundational document of collective bargaining agreements in the offshore contracts, masters, mates, and pilots. It was negotiated within a multi-employer association. That association has since disbanded, and the negotiations occur with each company individually. But it still is foundational for multiple contracts, meaning that the language that was relied on here is in many other contracts, but that to change it or correct it couldn't be done at just one negotiations table because it is now broken away from multi-employer negotiations. And so this decision isn't just applicable to the company here, Sunrise Asia, but actually impacts all of the, or many of the offshore agreements that master, mates, and pilots has, because they also have that 1981 underlying document as part of its contract. And so this ruling, therefore, really destabilizes relationship with other employers because it gives a play. If the union has a really expensive grievance that you don't want to arbitrate, simply refuse to arbitrate. And if masters, mates, and pilots goes to the National Labor Relations Board, even if they can show that, in fact, there are statutory employees in that unit citing this case, they don't have to rule on it. They can just say they don't have jurisdiction. And so it's a very important decision to the union to not have stand because of that basically, free pass for any offending employer. And it's not just masters, mates, and pilots. There are other maritime unions that have officers, and this is destabilizing for those maritime unions, and in the entertainment industry and construction industry, where you have multi-employer association negotiations and leads or professionals with skills that have to direct other workers. This has application in all of those places. And I think that the amicus brief does a nice job of diving into that. The second point is that the second and third mates come onto the ships through a hiring call. So they are not selected by the employer. They don't interview them or get to choose who they pick. They come on because they have a defined set of skills and meet requirements, and then are dispatched through the union hiring hall. And they're only on there for 120 days, or maybe even less if they're replacing someone who is sick on board. So this isn't the type of aligned supervisor picked by the company. It is someone who has a skill set that comes on and off various companies throughout the course of their career, and really goes to the professional nature of the positions, not that they are supervisors that are more aligned with a company than the union.
Ms. Demidovich, are you arguing that the board's ruling is novel and unsupported, or that it squarely conflicts with prior board precedent? And if it's the square conflict, I take you to be relying principally on Arizona Electric, but in Arizona Electric, there was a stipulation that there was a supervisor, whereas it seems to me the clearer potential conflict would be Gratiot. I just want to sort of test out the precision of your position. Is it a conflict? Is it just new? If it's just new, is the burden to justify as weighty on the board?
Well, it's hard to say, in all honesty, because there isn't a case that's squarely on point. Here, we were midterm in the contract. The contract did not and does not expire until 2027. So in 2015, when they voluntarily assumed the collective bargaining agreement, they assumed agreement in place until 2027. And so in Union Plaza, and I believe also true in Arizona Electric, there was talk about, well, at the end of the contract, it may look different than during the term of the contract. But here we have a situation where there's not a stipulation as to supervisor status. We were in the mid-contract term. So I'm not sure that and there's never been a case that has said that the board lacks jurisdiction to enforce a contract midterm that isn't all supervised.
I thought your argument was the board walked away from existing precedent with no justification for what it would have done, and indeed the board decided suddenly it wasn't presented to the ALJ. This went off. Well, that's what Judge Pillard is asking. What's your presentation here? In an agency case, I thought you were going after them, as parties frequently do with an agency, when the agency decision makes no sense. And I thought you were saying it makes no sense, one, because the record doesn't support it. Indeed, the record goes just the opposite way. There can't be a fight over whether they were or were not supervised. The ALJ decided that, and the board did not dispute it. The record's clear on who was and was not supervisors. And I thought your argument was, look, Your Honor, how can they reach this decision? This is a unit that is recognizable. They're charged with knowledge of the people who are in the unit. And there's never been a case that I can find anyway, ever, which says we look to see what the employer thought. There's no case. Now, I'll hear from the other side. Maybe they found one between the time I prepared and today. There's no case. But the point I'm making is I thought that was your argument.
That is.
I don't much care about the history. I understand the history. I didn't think that was the point of the case. We understand all the bargaining history. All the point of this case is there was an existing lawful bargaining unit, and the only fight before the ALJ was whether there were some non-supervisory people, and that's all the parties thought was an issue. Sunrise didn't argue anything other. The whole fight was supervisors or not. The ALJ said there are some employees here, and the board did not overturn that finding.
Correct.
Well, in that kind of a unit, the board's supposed to recognize it, right? Isn't that the law?
Yes.
Well, then there is established law, and the board walked away from it with no explanation, right?
That's right.
Okay. Is that your position?
That is our position.
Okay.
All right, and I'm specifically confused by your saying that there's no direct conflict, because it would seem to me that there's quite a direct conflict, at least with Gratiot, where if the board in Gratiot had begun with the threshold inquiry that the board began with here, whether the employer understood the unit to be mixed, it would have concluded that it lacked jurisdiction to enforce, because in that case, the collective bargaining agreement itself said that it excluded supervisors within the meaning of the act. And so the understanding, as here, where the board points to the agreement and says it describes people as supervisors, there the agreement described the people as only employees. So I'm just not sure why you aren't relying more squarely on what, at least on its face, would seem to be a direct conflict with prior board.
I thought you just explained in answer to me that that's what you were meaning to say. This is inconsistent with established law, no?
I guess where I'm getting a little confused, but in agreement with what you're saying, is that yes, it is. Our contention is that the decision is squarely contrary to established board law. Period. And in many ways, not just in one way. In many ways, is it squarely in conflict. In one way is that if you no doubt that if you have a mixed unit and you're mid-contract, the board has jurisdiction to say follow the contract. That's established. The second established principle that seems to not have been followed here is that you can't rely on titles and paper authority. It matters what they do in fact. Right. That's what the ALJ followed, and the board decided not to even address.
And the board law is you're presumed to know who's in your unit, no matter what the contract says. You can't change the fact of supervisor versus employee by pointing to the contract, which is a fabrication, arguably, and make it so. The board law is clear on that. Right. It doesn't matter that the contract appears to suggest that everybody here is a supervisor when in fact everybody is not a supervisor. That's right. Law. That's right. That's not just a great argument for you. That's the board law.
That's correct. And also the law is that this court does not have to defer to the board's interpretation of the collective bargaining agreement, and that the collective bargaining agreement, when it's referring to supervisor, isn't referring to supervisor in a 211 sense of the act, but is talking about jurisdiction between different units. The licensed deck officers are not the only officers on these ships. There's also engineering officers. So when you're saying supervising hull maintenance, supervising cargo, you're talking about that's the licensed deck officer turf versus the engine room, which is the engineer officer's turf. It's referring to a different aspect. It's not thinking in narrow terms of the National Labor Relations Act. It's thinking in terms of we've got these different officers who are highly skilled and have a lot of education and have a lot of pride in what they do on very close quarters together for 120 days out in the middle of the ocean. You know, let's say who's in charge of what and regulate that. And that's what hull maintenance and cargo supervision is referring to. And for the board to interpret on their own that in their framework of a 211 supervisory status isn't consistent with what the parties understood back in 1981. But to your point too, the board has always looked at what are people doing now.
Right. Well, that's what I'm saying. Again, I hear what you're saying about the reality, but the fact is you have an ALJ finding that the board doesn't dispute. And a party can't walk away under existing law, and not just a good argument. A party can't walk away from the reality of the status of the employees who are in the unit. The ALJ said certain of these people are not supervisors. The employer can't walk away from that by saying, that's not what I ever understood. Now, in this record, did the employer ever, during this 40-year period, did the employer ever voice that as an argument?
Well, so there's been many different employers for these four ships.
Well, any of them.
But not that, it's certainly not in the record.
It's not in the record. Well, but that's a point to make. There's nothing in the record that says that the employer ever called raised any argument up until this point. And indeed, before the ALJ didn't make this argument.
Correct.
Right?
Correct. And they have the burden of proof to do so. And they didn't even raise any kind of challenge about being supervisors until 3 years into the time after they had acquired the unit. So they voluntarily assumed the contract. They go to arbitration on 2 other cases. Then, after going into negotiations, so there's a reopener in the contract where you can cover any topic except for the term of the agreement, which ends in 2027, and the defined benefit pension. But anything else is fair game. They don't change the arbitration provision in those negotiations. And then 2 months later, all of a sudden, they say, we're not going to go to Linthicum Heights, Maryland anymore for arbitrations. They're on the West Coast. I don't want to make the flight. And so I'm going to stop letting anything go to arbitration. And so therefore, they stop, and we have to go to the board to enforce this 1984 part of the contract that says that the arbitrations happen in Maryland. But the point is that wasn't raised, and then the defense was only that the supervisors, they are in fact supervisors, which was litigated at the hearing, was their defense to 3 years after voluntarily assuming the agreement to why they didn't have to go to Maryland.
Now, I take it the board's position on that is that the employer could have thought, I'm recognizing the union, I'm negotiating with the union, but not in any kind of board enforceable sense, just informally. And is that implausible? On what ground?
Well, so one thing is that the board decision didn't say that. The board decision says that both sides have this understood intent that they're.
So both sides maybe thought we're just doing this because it's a convenient way to negotiate as private parties. It's our custom. We actually haven't resorted to the board because that's not the kind of bargaining we're doing. So what sort of.
Right. So the problem with the board saying that is that that's not supported by the record. The record shows that, in fact, there were 50 unfair labor practice charges filed over the course of the current general counsel's 20 years representing the unions. In the record, that there were multiple charges. And, it wasn't even in dispute that the MMP has gone to the National Labor Relations Board to seek enforcement of this agreement. Again, we have the same underlying 84 agreement. And I'll represent to the court, this is not in the record, but in 2014, in another case against Matson, which has the same blue book, the 1981 Agreement Foundation document, said we strenuously contest the concept that Matson, chief mate, second mate, and third mate are statutory supervisors. So, this idea that they haven't utilized the board and that they have somehow have this understanding that they're statutory supervisors is simply not true. There's not record support for it. In fact, the record goes the other way to suggest that the union is going and filing charges and not.
What's the section in the board order? What does they quote section 21 of the 1981 CBA? Duties of officers states the parties agree that the duties of the licensed deck officers, including masters, shall be maintained as supervisory and professional. Now, they put that in the order, they don't discuss it. What's your interpretation of that provision of the CBA?
The interpretation, again, is more in the sense of responsibility and consistent with maritime law. There's similar language in maritime, the understanding of the nature of the role of directing the ship. But since 1981, and in this record, there's evidence that, in fact, because of the constant technological communication with shoreside, that the regulations and international conventions require a designated person ashore and constant contact with that designated person ashore, that those kind of 211 supervisory duties have moved ashore. And in fact, in the record, there's an example of the captain wanting to terminate a chief mate and shoreside management saying, no, you can't terminate the chief mate. So back in 81, even if, and we will not concede that it means 211 supervisory, but even if it meant in 1981 supervisory, consistent with the act, that doesn't mean that you're forever and always bound by that statement then. When there's technological changes, industry changes, the crew sizes have gone down, and there's many cases, including Brusco, Tug, and others of this court that have recognized.
My question really was, having put it out in their order, there's no discussion of what it means by the board. Okay, that's one, to me, an internally inconsistent part of the board's order. Also, toward the very end, it throws out this sentence: the respondent seeks to continue the parties' bargaining relationship as it has existed for 40 plus years, outside the board's jurisdiction, as is common in maritime industry labor relations. Now, didn't you just say that there have been over 50 ULPs that the board has considered, or did I misunderstand you?
Well, filed. That doesn't mean that they have gone up to board decisions. So there's been ULPs. So
is the board wrong when it says for 40 years these two parties have been operating outside the board's jurisdiction?
Yes, the board is wrong with that. And two, there's certainly no record support. And if it had been framed that way at the ALJ level, we could have put in more evidence. I can tell you there's been 8 cases under that have the 1981 agreement as a foundational document that were filed by masters, mates, and pilots between 2009 and 2021. And none of those cases was supervisory status conceded, in fact.
Okay. Are there any more questions? All right. We'll give you a couple of minutes to reply.
Thank you.
Ms. Isbell. Morning.
May it please the court, Kelly Isbell here on behalf of the National Labor Relations Act. The board's decision here is limited. It simply found that it does not have jurisdiction to act in this particular case because of the unusual circumstances.
Well, I mean, that's an interesting approach. And if I were in your shoes, I'm not sure how I was going to ask you kiddingly, was there a lottery drawn and you got stuck with this case? Because I'd be very honest with you, since I'm one of the judges here and one of the three people you have to address, in my view, the majority decision is a paradigm of an agency decision that is devoid of reasoned decision-making for a lot of reasons. It walks away from existing board law. Recognizing mixed units is longstanding and perfectly appropriate, and the board can't walk away from it. It creates new law, that is, board looking at what it perceives to be the understanding of the employer or the employer and the union, as opposed to the facts in the case. It doesn't address the ALJ critical findings. It addresses a case that wasn't presented to the ALJ, and I go on and on. The dissent in this case is exactly right. The dissent was scratching his head like in disbelief, because I was in disbelief. This case makes no sense in terms of how we are supposed to look for reasoned decision-making from an agency. And that's why Kiran will ask you, well, you must have died when you got this assignment. And you're smiling nicely, and that's polite, but this case makes no sense. How can we deny the petition when there's no reasoned decision-making here?
I will say that the board applied its mixed unit decisions to this unusual fact pattern. You're right, there are not very many mixed unit cases to begin with, and there are maybe no cases that come to the board in this particular posture. But the board looked at objective indicia of the parties' understanding.
No, they do. What's the objective addition?
The 40-year bargaining history,
right?
The language in the contract, which does not establish, the board is not saying the language in the contract establishes.
No, you anticipated my question. That's not conclusive. Okay, the language absolutely not conclusive.
And the board would agree.
And the case law is, as you understand, whether there are only a few cases or not, the case law is undisputed, that the parties are bound by, they're assumed to understand, or they're assumed to accept the reality of who's in the unit. They can't, after the fact, say, oh, we didn't really understand that way. The case law from the board is, look, if you sign into that mixed unit, you're presumed to understand who's in it. And the way we measure who's in it is by an objective standard, like the ALJ did.
2 points.
Go ahead.
One, both parties are being held to their collective bargaining agreement. So that this is midterm. This is not end of term. This is not, in our case, a representation petition where the parties are trying to decide who's in the unit. This is midterm contract.
Right.
The board does not disturb a contract and the unit scope, who's in the unit, who's out, in the middle of a contract.
But the decision does just that. It refuses jurisdiction.
It refuses jurisdiction because the board is holding both parties to the contract, which says these workers will be treated as supervisory.
It doesn't say that.
It doesn't say
And
that.
it certainly doesn't refer to supervisory in the statutory sense.
No, it absolutely does not.
And it's not conclusive. You started off by acknowledging that. That's not conclusive.
The board made no finding about whether or not these workers are, in fact, dual-level supervisors. To the board,
In fact, it thought that was irrelevant, which is stunning, because even if the board adheres to its understanding test, surely it is relevant to whether an employer has a reasonable understanding what the employees actually do and what they're found to do. If the employer has any idea about its own workforce, then the plausibility or reasonableness of the claimed understanding would be affected by the finding about the workers, and the board does not treats it as a completely irrelevant. How could that be?
Because in the board's view, based on those objective indicia I mentioned, including the union's own statements to the board and courts over the years that this is a supervisory unit, that the parties, when Sunrise adopted the bargaining agreement, so Sunrise just came in and adopted it cloth. They did not negotiate with the union. As far as I can tell, they did not even talk to the union. They adopted, there's a part of the record that says their contract with Horizon is they just adopt all of Horizon's obligations. They come in and they take it. But there's no negotiation about who's in and who's out of the unit. They have this 1981 agreement that says this unit will be supervisory and professional.
This is all made up nonsense. Let me tell you why, and this is what blew me away. The ALJ didn't try that case. And then the board's blaming the ALJ. The ALJ did exactly what the ALJ, if the company had that case to present, what they forget? And then the board made it up. The company did not argue that before the ALJ. The fight was over. Well, in fact, everyone's a supervisor. Okay, that's the issue. I'm going to take it on because everyone understood if they're not all supervisors, this unit has to be recognized. Everyone went to the ALJ with that understanding. The employer never raised the issues that the board then picked up on. That's blatantly unfair, for one thing.
If I may address that particular issue. During the hearing, the company's counsel did ask, were you ever certified by the board?
Doesn't matter.
Well, in my mind, it does.
In your mind?
Yes, I'll get to a bigger.
Okay, go ahead.
Okay. Or were you ever recognized as the 9A rep? Okay, meaning, are there employees in this unit? The answer was no, we didn't ask for those things because they don't need to, which is fine.
Right.
Post-hearing briefs, we're arguing Union Plaza, that this is a mixed unit. The ALJ finds this is a mixed unit and Sunrise has an bargaining obligation. The board, what she actually says is the board has jurisdiction because this is a mixed unit. They're both employees. Okay. Now, on exceptions to the board, now we are squarely, once the ALJ makes that finding, this is mixed. You're squarely in the mixed unit case. And Sunrise, in its exceptions to the board, says, wait a minute, you don't have jurisdiction because still, these are in fact supervisors, but also the mutual intent of both parties was that this is a supervisory unit, as expressed in the collective bargaining agreement. They cite cases where the union has asserted to the board and the courts that this is a supervisory unit over the years.
Why wouldn't that have been an issue before the ALJ if that's what Sunrise thought was really going on, the mutual intent of the parties? That would have been litigated before the ALJ. That's the way those things work. If that's really their theory of the case, this is made up after the fact. The parties litigated one point, supervisor or not. Everything else is within the jurisdiction, and their argument, the whole argument before the ALJ, before the trial going to the board, was, are all of these people supervisors? And Sunrise felt we rise or fall on that. That was the case. And the ALJ credibly found the company was wrong, and the board did not reverse that finding.
The board did not reach that finding. Did not reverse, but it also did not review.
That's exactly right. Didn't reverse it or review it. Just ignored it and said, no, we just want to see we want to tell you what we think the company was thinking. That's not the way the board has no support for this approach whatsoever. None.
Except the factors that it relied on that I've mentioned to you. And the board doesn't see this as an affirmative defense that Sunrise raised. It sees the board, in the board's decision, the board is saying the ALJ should have asked this extra question. And the parties were discussing mixed unit cases and Union Plaza in their post-hearing briefs to the...
But that's what's confusing, because the board's approach typically has been, first, is this in fact a mixed unit? And the ALJ found that it is, and that was in the plan and in the exceptions, that these are supervisory. But and then one might imagine that there would be a defense. Look, I really didn't engage in this voluntarily because I had no reason to think. The description in the collective bargaining agreement and whatever. But to say that at the beginning, without even inquiring into the full facts on the ground, that this paper reference in a palpably different context to supervisors is enough to terminate jurisdiction, that is not with the board. No, the ordering of the inquiry.
Well, I will certainly say that I can't find any other cases that have come up in this particular
You certainly can't.
context.
I appreciate your patience, your indulgence with this attack from this part of the bench. It's not personal.
I knew you would be interested.
Right.
I'm sorry, didn't answer your question.
I was just going to ask about the text of the agreement, which is really the board leans very heavily on. And wouldn't it have to have some relationship to the statutory supervisory issue in order to vitiate the employer's understanding that this is a mixed unit?
Text of the collective bargaining?
Yeah.
Not necessarily. In our representation proceedings, parties can agree that employees are in units. They can say, we're going to put this accounting manager in, and that person may or may not be a supervisor, and they may argue about it later. But they can decide who's going to be in and who's going to be out. And they do not, in their contract, have to say, we are putting 211 supervisors in, or none of these people, we promise, are 211 supervisors. They can make an agreement.
But to exclude them on the ground that they're not under board jurisdiction, there would have to be indicia that these are people who are not under board jurisdiction, whereas probably the way the term supervision is used is supervision of ship parts, not of human beings with, discretion and responsible hiring and firing and discipline functions. It has nothing to do with humans. In fact, it's possible that in supervising hull maintenance and cargo gear maintenance and the like, that there are no subordinate humans involved.
And I will say that may in fact be true. I mean, I can go through the record and give you examples where they are, but that doesn't, to the board, it doesn't matter, right? The board made no findings that these were actually supervisors.
They just told us their understanding. It's absurd.
So my arguing that they maybe are is outside of my board decision.
Okay. All right.
Thank you, Your Honor.
Ms. Cooper.
Good morning, Your Honors. My name is Kara Cooper, and I am counsel for the intervener Sunrise in this matter. And I just wanted to talk briefly about the record in this case, because we believe that there is adequate record upon which to conclude that Sunrise voluntarily recognized a purely supervisory unit. So first, what we've talked about so far today is that Sunrise proffered its CBA, the 1981 CBA, the unfair labor practice hearing, and we think that this is the best indicator of what Sunrise was thinking when it assumed the bargaining unit, the bargaining agreement in 2015.
Why didn't you present that case to the ALJ?
To the ALJ?
Yeah.
Well, we did introduce the CBA.
The theory that the board announced was not presented to the ALJ. The board went off on its own with a theory you're comfortable with now. But that was not the case tried before the ALJ.
I believe and I know you don't agree with this, but in our affirmative defense, that we believe that these are all supervisors and therefore the board doesn't have jurisdiction.
So you're not defending the board decision because that's not the basis of the board decision. The board did not hold that they're all supervisors.
Right. Yeah. So we have a different position in that we believe that they are all supervisors and that our affirmative defense, when we said that they're all supervisors, that affirmative defense is we believe them to all be supervisors. Therefore, we did plead an affirmative defense. But I understand that's not board.
So you think the ALJ had the theory before her that what the employer believed is dispositive and she had to decide that and failed to consider what you were raising? The ALJ was not considering what you're now arguing. You're kind of going in between the ALJ and the board, leaning toward the board, but certainly not the case that was presented. Everyone understands that what we're arguing about now is not what the ALJ had before.
I do think that there obviously was this discussion of mixed units and whether we had recognized a supervisory unit or a mixed unit.
Right. And it mattered. The ALJ thought it mattered. In fact, what are the people doing in this unit? Because that answers the company's question, either favorably or unfavorably. If I find there are employees in a unit, then the company loses. That's what that's the ALJ's case. You're shifting it now artfully. The board brutalizes it. But it's a different case. I don't have to go any further, to be very honest with you. In my mind as a judge looking at an administrative proceeding in all the years I've done this, that can't happen. But no other reason than it's not fair. You can't try cases like that.
And Your Honor, as you know, the board faulted the ALJ for not doing the initial analysis as to whether Sunrise voluntarily accepted a unit of supervisors, whether they had knowledge to that. So to answer your past question about the mixed unit and why the ALJ didn't rule on that, that is what the board spoke to.
Okay.
So you're arguing that you did argue before the ALJ that your client had didn't voluntarily recognize the mixed unit because it had no understanding that it was a mixed unit, apart from whatever the realities on the ground are. It had no understanding that it was a mixed unit.
That's correct.
You made that argument before the ALJ.
I believe we did.
Yeah.
Can you give a citation in the record for that? Because that would be, key to some of the questions about preservation, waiver, estoppel.
No, it was just based on our affirmative defense, which I believe.
So you characterize it as an affirmative defense, and that is more the conventional understanding that I have, is that if there were a basis for the employer to say, I had no reason to think there were any supervisors in this unit, that it would be an affirmative defense on the merits, not something that would deprive the board of jurisdiction. Is that also your understanding?
I think it can be both. I think it can be affirmative. The way that the ALJ was thinking affirmative defense was that was merit, because it determined whether the LDOs were supervisor or licensed officers or supervisors or not. But I would say the affirmative defense also can be looked at as if you look at the board's decision in saying that, Sunrise's belief as to supervisory status of the LDOs is the initial.
Great, thank you.
Thank you.
Why don't you take 1 minute?
Yes. I'll try to do it even shorter than that. Just want to make one point, which is that the union at the hearing didn't take the position that it was a mixed unit. We took the position that none of the licensed deck officers were supervisors. And in fact, we put in evidence that the captains and the chief mates were statutory employees. And so then when we get the board decision that says we have this understanding that they're all supervisors, when in fact we litigated that they were all of them were statutory employees, was a complete about face. Never was it argued what MMP understood. In fact, our whole argument was that they are in fact employees, and never was it argued what the employer understood in 1981 when the contract was negotiated, in 2015 when it was assumed, or in 2018 when we went back to the table and this issue did not come up. So I agree 100% that it's a fundamentally unfair decision. When I read it, I said, what case is this? Because having litigated the ALJ decision, I didn't know how you could even come up with the decision that the board did. It wasn't the same trial I was at. It's not supported by the record. I was just very glad that there is court review.
Ms. Domenovich, what about the JA 12 and the board's decision at footnote 8? The board says respondent recognized. I'm sorry, I'm reading the wrong footnote. The older cases it's earlier, the older cases that the board relies on, it is, JA4, note 7, numerous federal courts have either found union represented LDOs to be supervisors or treated them as such, and it cites several admittedly older cases in which the union affirmatively so asserted that they were statutory supervisors. How do we work with those?
Sure. So that wasn't something that came up through testimony at the hearing. It was something argued in the brief, and we did know of the existence of those cases and anticipated them. And what we argued in response is, first off, the 1975 decision where MMP, took a position on supervisory status predates the 81 agreement. It's not even clear that it's an offshore unit that applied to, but also that since then, technology has changed, the way that supervisory status is reviewed has changed, and that maritime law has changed and the composition of the crews has changed. So we litigated that, in fact, times have changed so that you can't, and case law has changed so that you can't use those 70s and 60s decision to say what, in fact, should be ruled on for these workers today.
I should have asked the board, but where you have a unit that the ALJ has determined is in fact mixed, in other words, there are some employees, some non-supervisors in the unit, do those employees continue with representation or everybody loses it?
They can enforce a mixed unit, so everybody would continue to have representation.
But I'm saying under the board's ruling, were the board to, remand to the ALJ, get substantiation, if we don't reverse the board's ruling, does everybody lose?
Yes.
Why wouldn't the employees who nobody disputes because they're understood by the employer to be supervisors?
The board's saying it has no jurisdiction. It's saying it's not a viable unit. So the board is effectively saying so the employer can walk away from it.
Right. So we can't get the information that we were entitled to under law. We can't go to arbitration.
So if those employees wanted to organize and leave out the people who the employer understood to be supervisors, they would have to start a new unit.
It's not clear. I mean, the board just says, oh, just go file something else. I mean, and you saw with the motion for reconsideration, 2 of the 3 said it was wrongly decided. It said just start anew, go back to the board and file something for, so it's not exactly clear how you would play that out. Certainly.
What's clear is the board said the employer can lawfully walk away from this. Obligations that would otherwise be enforced under the NLRA, the board says will not be enforced for anyone, the employees or the supervisor.
Even for statutory employees.
So we're starting there. That's all the board tells us.
Correct.
Which is unprecedented.
Correct.
Right, thank you.
Case number 21-5266, Federal Law Enforcement Officers Association, Appellant versus Kiran Ahuja in her official capacity as Director of the United States Office of Personnel Management and Office of Personnel Management. Mr. Griffin for the appellant, Ms. Mohan for the appellees.
Mr. Griffin, good morning.
Good morning, Your Honor. May it please the court. Section 8467 of Title V contains Congress's instructions to OPM on how to interpret and process divorce court orders when administering federal retirement benefits. The statutory instruction is clear. OPM may pay federal benefits to someone other than the retiree only to the extent expressly provided for in a divorce decree. The purpose of this standard is equally clear, as recognized by the agency itself when it implemented formal regulations for this act. And that is to keep the federal government out of the substance of marital property disputes and to restrict OPM to a purely ministerial role. In 2016, after nearly 30 years of administering the current retirement statute, OPM took an interpretive U-turn. Without any notice or opportunity for comment, it decided that the expressly provided for standard does not apply with respect to the annuity supplement that retired federal law enforcement officers receive as a stand-in for the Social Security benefits for which they are ineligible during the period from their statutory retirement age until age 62. Instead, for this benefit and this benefit alone, OPM began looking only at whether a divorce decree expressly divides an entirely different federal benefit, that is the basic annuity provided to all federal civilian employees. If so, OPM will now automatically apportion a retiree's supplement along with the basic annuity, regardless of what the decree says or doesn't say about the supplement. One group of affected retirees, those whose basic annuities were already being divided, but who were receiving the entirety of their supplements at the time of the rule change, immediately saw cuts to their retirement income. Not only that, but OPM applied this new interpretation retroactively and began clawing back portions of annuity supplements from retirees whom it had already paid in full.
You're going to get to the jurisdictional issue?
Yes.
It's a big one.
It is indeed.
And we can't do anything if there's no jurisdiction.
You are correct. And I was about to get there, but let me turn to that now.
And please, we have a rule against reading. Don't read.
Just talk to us.
Sure. OPM argues that you don't have jurisdiction for this case because it says that this court's opinion, Judge Edwards' opinion in Devine, is no longer good law.
Mine's gotten beaten up over the years.
Well, I'm on your side here. We believe Devine.
Well, you don't know what my side is because I now
Well,
struggle with the cases.
Fair enough. We're on the side of Devine. We think Devine is wholly consistent with later cases, including Thunder Basin Coal, that draw a clear and workable distinction between claims that effectively resolve individual benefits and are appropriately channeled through the MSPB and traditional APA rulemaking claims, which, as Judge Henderson, as you noted in the Knapp Medical Center case, there's a strong presumption in favor of judicial review for those type of claims.
What about Fornaro
Right.
and Elgin and the AFGE cases? I mean, Fornaro is pretty explicit at saying even if it's a systemic challenge, if it's a challenge to a broad policy, it has to go OPM, MSPB, Federal Circuit.
Well, Fornaro and Elgin, Fornaro was not an APA claim. So what the case in Fornaro was plaintiffs seeking a writ of mandamus. The individual plaintiff seeking a writ of mandamus in the district court, asking OPM to change their individual benefits. There had been a recent Federal Circuit case that had granted enhanced benefits to one group of retirees, and they said, we think we're entitled to that too, district court, please tell OPM to change our benefits. Elgin was also not an APA case. That was a constitutional claim challenging the constitutionality of the Selective Service Statute. In both of those cases, what the key distinction is that they resolve individual claims. So after those cases, the plaintiffs before the court were going to have their decisions changed or not. We're not asking the court here to resolve any individual claims.
But I mean, maybe you should be. You're characterizing it as not asking for change in individual claims, but you're absolutely in here on behalf of and representing individual claimants who are dismayed at what's happened to their payments. So it's not pre-enforcement, which is the line I thought you were drawing. to put yourselves under divine. There has been and is ongoing enforcement, as your complaint itself alleges, that you're seeking to halt the continuing application of this policy.
Well, it is pre-enforcement for two groups of people who are presently adversely affected.
It's the same policy. The fact that enforcement hasn't reached everybody doesn't mean that it's pre-enforcement.
Well, it is
Same policy. It's one policy.
It is the same policy. But even for people whom it has already reached, what we are asking is not for the court to look at a divorce decree and decide what it means. So our view is that in order to decide an individual case, what OPM has to do is apply 8467, the expressly provided for rule, and look at the decree and see, does this decree, the specific language in this individual case, expressly provide for division of the supplement? OPM says, no, we don't have to make that inquiry at all because 8421 says we just do that inquiry for the basic annuity, and if so, we divide the supplement too. And what we're saying is, no, tell OPM they have to go back and apply 8467 expressly provided with respect to what the divorce court says about the annuity supplement. And how particular language in a divorce decree will come out in an individual case, we don't know. We're not arguing because we're not taking an issue with how OPM reads and applies that expressly provided for standard. All we're taking issue with is whether they apply it at all with respect to the annuity supplement or they just skip that step. And that's why there's no individual decisions here, even if we had individual plaintiffs with individual decrees in front of the court.
So tell me how you're getting around Fornero, Elgin, and Fornero, allowing district courts actions challenging how OPM calculates civil service benefits for particular classes of beneficiaries would plainly undermine the whole point of channeling review of benefit determinations to the MSPB, the Federal Circuit. Elgin is saying, you say this, where is the case law that carves out a divine exception? I don't see it.
We think divine is fully consistent with Thunder Basin Coal. And so I would ask you to take a step back to the Thunder Basin Coal inquiry and walk through the framework. And I think you'll find that divine fits into that framework on one side of the line, and that Elgin and Fornero.
Where does Thunder Bay say we make an exception for pre-enforcement or for rules or for what? Well, I'm not sure how you want to characterize it, so I won't say that for you. But where does Thunder Bay say that? I think Thunder Bay is one of the cases that works heavily against you.
Well, I disagree on that point. So what Thunder Basin says is the first step you look at is, did Congress intend to preclude some type of cases? And the answer to that is absolutely yes. That's not in dispute. But the second step of Thunder Basin Coal is, okay, well, what is the scope of that preclusion? And this court has looked at that in a number of cases. We cite the Jarkisi v. SEC case, which says, okay, at step 2 of Thunder Basin Coal, you look at the congressional intent and figure out what kind of cases Congress was intending to preclude and what kind it wasn't. And
what case tells us, other than divine, what case gives us the answer to that question?
Well, the primary answer to that question is a question of what Congress intended. And so I will direct you to a statute, 8461, I believe has the answer of what Congress intended. And what 8461 says, 8461C says, for claims under Chapter 84, the FERS system, you bring those in the first instance to OPM. Chapter 84 provides individual benefits. And so it's talking about individual claims. 8461E says, if an OPM action affects the rights or interests of an individual, you can then bring that to the MSPB. And so you read those two together, and the scope of what Congress is channeling into administrative review is pretty clear. It's individual benefit claims. And now there's a second piece to that puzzle, is now that you know that, can you also infer from that, from that channeling of individual claims, that Congress also intended to channel traditional APA claims through that channel? And the answer is no. And the reason is, and Judge Henderson said this very well in that medical center case, there is a strong presumption in favor of maintaining jurisdiction for APA review. And we're not going to read Congress as writing that off unless there is specific language evincing a clear intent to channel APA claims through the administrative process. And here there isn't. 8461 just says you take individual claims through that process and doesn't say anything about APA claims, and that under the Nat Medical Center case should mean that they're still available.
You want to reserve the rest of your time, or?
Well, if I can turn to the merits, if we're done with the jurisdictional questions, let me just address that quickly. And I want to remind the court we have 3 claims on the merits. And let me start quickly with Claim 2. Claim 2 is a standard notice and comment claim. Our argument is that this is a legislative rule. Whatever you think the statute means, this is a legislative rule because it had an immediate impact on affected retirees. People immediately lost benefits. People immediately became indebted to the federal government for benefits they had received before. And so we would argue that that requires notice and comment rulemaking, and that without even getting into what the statute means, you should invalidate the rule and send it back to the agency to go through the correct process. Claim 3 is that OPM lacks statutory authority for retroactive rulemaking. And again, that's a pretty straightforward claim. This court has said in Health Insurance Association v. Shalala, and the Supreme Court has said in Bowen v. Georgetown Hospital that agencies have limited power, and we're not going to presume any power to make rules retroactively, including for interpretive rules, unless Congress specifically says you have authority to make rules retroactively. There is no such authority for OPM anywhere in the statute, and the agency hasn't pointed to any. And so we would argue that whatever you decide about the rule and the interpretation of the statute going forward, the retroactive application of it can't stand.
Doesn't your position depend on the notion that this is actually a change? And I took the government's briefing to characterize the practice as largely consistent with the reaffirmed practice, but that some of the staff who were implementing it were implementing the way you advocate, as distinct from pairing the basic and the supplemental annuity the way they now have expressly said. Do we know whether the past practice was predominantly in accord with your reading or not?
Well, let me answer that in 2 parts. So there was, like you said, there was some confusion apparently within the agency as to what the agency did, and that's reflected in the 2 requests for guidance that are in the administrative record. I think they're JA 57 and 59. But that confusion was not between our 2 positions. So the confusion among the paralegals was between some paralegals would get an order that expressly said, divide the annuity supplement, and they would do it because, again, 8467 says, do what the divorce court expressly divides you to do. Other paralegals in the agency were not sure whether they should do that. And the reason was because they see this supplement, correctly so, in our view, as a Social Security supplement. It's a stand-in for Social Security benefits for people who are required to retire by statute before they reach 62. And Social Security is not divisible. And so there was question about the debate between the paralegals was, do you divide it when you're expressly told to do it, or do you not divide it because it's like Social Security? There's no indication that the agency ever, prior to 2016, took the position that you divide the supplement even where an order doesn't say anything about the supplement. That, as far as we know and is from the record, is entirely new as of 2016.
And your support for the characterization that you just gave, which is very helpful, do we divide when it's express or do we override the expression that it should be divided because we treat this like Social Security, which is indivisible? The best record support for that is where?
I'm sorry, I'm not quite sure what.
So I asked you a question about agency practice and understanding, and you gave me an explanation of what you thought were the conflicts between the different paralegals' understandings. And I'm asking you, if that is in fact what was going on, where would you point me in the record to support what you just described?
Again, it's only, the record is very limited here, and so the only document that describes that conflict and that prior practice is the two requests for guidance, JA 57 and 59. And then just the one other question you asked, it's not anything in the record, it's the lack of anything in the record about doing what they started doing in 2016 prior to that. There's no indication that they had ever done that before.
Does OPM ever engage in rulemaking in the traditional sense?
Yes, OPM does, and they have there are formal OPM regulations relating to 8467 and how the agency processes divorce court orders.
Are there any judicial decisions on challenges to OPM's rulemaking or failure to rulemaking?
There are.
You're essentially, as I understand your argument on the jurisdictional question, you seem to be arguing that this is really a rulemaking or something that should have been subject to rulemaking. The agency didn't engage in it under normal APA procedures. We can challenge that. That's a pre-enforcement kind of issue. We can challenge their failure to engage rulemaking without regard to even getting to the merits. We can challenge that failure, and that's how we stay here. But there's no case law.
There are.
I'm not blaming you. I'm just asking. I couldn't find any.
We cited a couple of cases. We cited a few cases from the DC District Court in our brief that follow and apply this court's divine decision. One of them, the NTEU v. Whipple case in 2009.
Do you have any Court of Appeals decision saying that if and when the OPM rulemakes or fails to rulemake, that is subject to review under the APA, which would bring it in, take it out of the MSPB route? The MSPB doesn't handle rulemaking challenges, right?
That's correct.
Okay. I'll ask the government unless you know something to tell me. I mean, that's the part of the case that's perplexing to me. You're saying it's a rulemaking, a failed rulemaking.
Right. And I would just note that divine was a challenge to OPM rulemaking. That was rules regarding, I believe it was reduction in force rules, but it was a challenge to OPM rulemaking.
All right, thank you. We'll give you some time in reply.
Thank you.
Ms. Moen?
Can I start you before, and I don't mean to interrupt you, except I am, so maybe I do.
Not a problem, Your Honor.
Answer me on the rulemaking question. This case, as far as I'm seeing it, not definitively for the panel, the suggestion is you should have engaged in rulemaking here, and you didn't. And that's their challenge. And how does OPM engage in rulemaking? And if so, what is your position on how you challenged an alleged failure to rulemaking, or deficient rulemaking, or the merits of the rulemaking?
Your Honor, OPM does engage in rulemaking. I think in thinking about the failure to use notice and comment procedures here in that claim, it's really applicable to think of it under this wholly collateral question that's raised in Thunder Basin and Elgin. And what those cases have established is that where a claim, even if procedural, is sort of inextricably intertwined in the substantive claim that needs to be challenged through the statutory review scheme, then it cannot, you can't circumvent that scheme by bringing that claim.
And if we don't buy that, then you lose.
No, Your Honor.
Now, in other words, I don't mean to be glib, but I mean, if they're saying you didn't pursue rulemaking, you simply failed to, forgetting what we think about whatever it is you're proposing, you have to go through rulemaking. And that's our challenge. You failed to engage in rulemaking.
Your Honor, we don't lose if that's the case. I think in the first instance, that would at the very least mean that the two substantive claims challenging OPM interpretation of the statute would still have to go through the CSRA scheme. And I think the fact that that would be the case is what shows that the notice and comment claim also needs to go through the scheme. Because if you allow the notice and comment claim to be sort of severable and for this court to address it and not the federal circuit, you would have the very risk of inconsistent decision making.
Or let me change it this way. Suppose there isn't a challenge on the merits. You say you have a new rule in effect in their view. You've promulgated a new rule and you had to promulgate it through notice and comment rulemaking. You failed it. That a viable claim?
Your Honor, I believe that claim would still have to be channeled rather through the CSRA scheme.
Why? MSPB doesn't handle rulemaking challenges, as far as I understand.
I think Elgin is helpful on this point because there you had a constitutional challenge to the validity of a statute. And similarly there, the MSPB doesn't routinely handle constitutional challenges to statutes. And the court nonetheless said that the claims needed to be channeled through the CSRA scheme because you would ultimately get meaningful review on those claims from the federal circuit.
So is this the government's position there is no way to challenge a rulemaking?
Your Honor, I believe there are specific provisions within the CSRA that allow for challenges to rulemakings as unfair practices. I believe it's 5 USC 1204 specifies some rulemaking challenges that can go directly to the MSPB. But no, in this case, I think it's important to remember that.
No, wait. I'm just trying to get this the framework in my head. Is it your position that there is no possibility, everything has to go through MSPB? Is that what you're saying? That's what I just heard you hinting at. Everything has to go to I didn't think the MSPB took challenges to claims with respect to failed rulemaking.
Your Honor, if the claim, as it does here, implicates...
No, don't stick with my hypothetical, because that gives me a sense of what you're arguing in particular.
Your Honor, I don't think you need to answer the question.
No, but I do need to answer it in my head. I need to understand what the government's position is, because that'll help me to understand how far you mean to reach.
Our position is that where a claim implicates the calculation of federal retirement benefits and the statutes that provide for that calculation, it must be channeled through the CSRA scheme.
And do you want to try now and answer my question about, they're saying you had to use rulemaking to do whatever you just did, and you didn't. It looks new to us. It should have gone through rulemaking. Is that a viable claim ever?
Your Honor, it's hard for me to think of every conceivable situation.
Think of any conceivable situation.
And I'm sorry that I'm not being entirely helpful here, but again, I think that the key here is that any decision on that failure to rulemaking challenge would carry that risk of inconsistency with the substantive claims that are already proceeding through the CSRA scheme. There are 69 individual...
No, I understand that part of your argument. Just so you know, I'm not missing that part of the argument. I'm trying to understand, because it really leaps out here when you prepare this case, this question about whether or not there is a viable claim. You say, yeah, we rulemaking, and I assume that was probably so. But I want to know, there are lots of agencies that are subject to challenges because they didn't give notice and comment on something that was allegedly new, or they didn't do it properly. And I'm just wondering, and that's not normally an MSPB question. And I was wondering what the government has to say about that.
Your Honor, and I'm apologizing for not being definitive on sort of the entire universe of cases, because I really do think that the answer here is clear and confined to the fact that you have this sort of inextricably intertwined relationship between the failure to rulemake or the failure to follow particular rulemaking procedures challenge and the substantive claim. If, for example, the Federal Circuit, as a result of these 69 cases that are currently proceeding, says, we agree with OPM that the statute unambiguously requires the supplement to be divided in the same way as the basic amount, then there would be no reason to follow notice and comment proceedings for OPM because the text of the statute would allow for only one result. So that's why we believe that they're trying to parse off one of these claims versus the others risks the very inconsistency that the CSRA was intended to avoid.
Although, and I'm going to shift a little bit to the retroactivity question, because it seems like there's a relationship between these two things to the extent that the exhaustion going through OPM and MSPB is required where there might be a defect, a sort of facial reinforcement legal defect in the rule or a failure to make a rule that you're going to get further into a course of conduct that you might then have to undo if exhaustion is required. And I had a question about your claim that the government can recoup overpayments where they're made on erroneous grounds, which seems to be not entirely, like the authority seems to stand for that, and that's not entirely what we have here. So I guess do you have authority that would allow recoupment all the way back to 1987?
Your Honor, we believe those authorities we cited in our brief provide that authorization. There is also specific statutory authority in section 31 USC 3716, which talks about administrative offset and recoupment of payments. And then there are regulations that govern recoupment specifically in the context of these FERS benefits we're dealing with. So we think that if the statute has said this is the way that benefits need to be paid out from the start, then that is the way that OPM was required to be paying out those benefits beginning in 1987. And importantly, I would just note that to the extent that an individual claimant would face financial hardship from having to pay back an overpayment or maybe detrimentally relied in changing financial positions based on an overpayment, there is a waiver mechanism in 5 USC 8470B, which allows OPM to waive the collection of overpayments if it would be against equity and good conscience. And the regulations just implementing that provision specify that cases of financial hardship where the individual is not themselves at fault for the overpayment are kind of good grounds for that type of waiver.
I guess for me, a clarifying question, which is the flip side of what I asked, or the same question that I asked Mr. Griffin, is what was the past practice? Was the past practice largely in accord with your current interpretation or not? And how do we know?
Your Honor, it's difficult to say. There was no formal regulation or formal interpretation of the statute via adjudication that is different from what OPM is now saying. My understanding is that a lot of this was occurring via computer coding and individual specialists interpreting court orders and making determinations. Again, we don't have evidence in the record about sort of the practice across the board, but as plaintiff's counsel raised, there are letter questions that individual specialists had about when a court order specifies something about the supplement, what do we do? I think part of the reason maybe those questions hadn't arisen to that point is that OPM has promulgated regulations that give state courts some terms that they can consider using when they are issuing these divorce orders. And those terms don't use words like basic amount or supplement. They say gross annuity, net annuity, FERS benefits, benefits earned through service in the U.S. Department of Agriculture. So
I don't hear you saying that it's clear that there was no new interpretation. It seems like we'd be on pretty safe ground to say that the 2016 interpretation is a new interpretation that conflicts at least with some body of past practice. And so there's more of a retroactivity analysis that you'd have to go through in order to be able to recoup, no?
Your Honor, I think to the extent there's a conflict, it's only with that sort of informal operational on the ground practice. And that I think feeds into the retroactivity question because cases like Health Insurance of America, Association of America versus Shalala say, if the agency is just saying this is what the statute that was in existence at the time required, it can apply that retroactively. If this court were determined, for example, to only side with OPM based on deference to the 2014 policy, then maybe there would be a different question about retroactivity, and we think Shalala stands pretty clearly for that proposition. So if it were solely a question of deference, maybe OPM could only go back to 2014. But since our primary position is that this is what the statute, this is the best reading, this is the plain reading of the statute and what it's always required.
I mean, I think the more fundamental question is where is your statutory authority to promulgate a rule with this kind of retroactive effect? And, really reaching back and changing, not changing things that people relied on, changing the legal landscape, at least with respect to some body of these recipients. And I didn't see you citing that.
Your Honor,
It's just the general authority to administer all provisions of this chapter, right?
We don't contend that OPM has specific retroactive rulemaking authority, but we don't think that changes the position here because, again, it's our contention that the statute has always required this result, and to the extent that specialists in internal operations were doing something different, that was an error at the time, and it remains an error to this day. And OPM has authority to collect and resolve those errors.
So you're arguing that an interpretive rule can't be retroactive, but I thought that in Georgetown Hospital we rejected that notion that just because it's interpretive doesn't mean that the rule that is effecting some kind of substantive change necessarily reaches back to the statute.
Your Honor, I think the key question that case raised was whether the court is deferring to the interpretive rule or not. So if you have a situation where you have an interpretive rule that is filling a gap and the court says, look, we don't think this is necessarily the best reading of the statute, but we are going to defer to this rule that you promulgated, then you can only reach as far back as that rule. And we don't contest that. If this court were to determine that OPM's right on the merits, but only as a result of deference to the 2014 memo, we don't think that OPM could collect before 2014. But because our primary position is that the statute has required this all along as the unambiguous best reading, we think that OPM can go back to correct those errors.
All right, thank you.
Thank you, Your Honor. If there are no further questions, we ask that this court vacate the judgment below.
All right. Mr. Griffin, why don't you take 2 minutes?
Thank you, Your Honor. I wanted to just very briefly address the retroactivity issues you were just talking about. And I just want to point out that there are 3 main cases the government relies on, and none of those involve retroactive rulemaking. So they cite OPM v. Richmond, King v. OPM, a federal circuit case, and then US v. Leahy Clinic, a First Circuit case. And one of those is about whether a estoppel runs against the government. One is about OPM's statute that allows waiver of recovery for various equitable reasons. One is about the government's common law rights of recovery under state law. None of them are about rules being applied retroactively. And then, if I can very quickly, Judge Pillard, you asked about whether, for any evidence in the record, whether this is a change. And again, there's nothing that really documents the agency's past practice in the record. But I think when you read the advice memorandum, and I'm looking at JA 60, the first page of that 2014 memorandum, it's pretty clear that the agency itself understands this as a big shift. And so what they say is, after careful review, we've determined not only does 8421C obligate OPM to honor provisions that expressly divide an annuity supplement, this provision also requires OPM to divide an annuity supplement in circumstances where a court order simply divides a FERS annuity benefit. And I think just the language of that makes clear is, hey, we just discovered how this works, and this is different than what we were doing before.
And so your view on the line between retroactive and prospective is what? How would you draw that line? Clearly, they have authority to clarify going forward.
Yes. Right.
What
did you say?
Clearly, they have authority to clarify their policy going forward. They think it's in conflict with the statute, and they have an obligation to comply with the statute. If we were to hold that their reading is correct, but is in fact a change from past practice, that would trigger a retroactivity analysis. And what is your view about where the line between retroactive application and application to current cases is drawn?
So that line is the line between benefits to be paid out in the future and benefits that have been paid out in the past.
Benefits to be paid out. So somebody who's received some but not all. Then the change in their case would happen.
These are annuity benefits paid out in monthly installments. And so the July 1, 2016, when this change went into effect, it both changed people's monthly payments going forward, and the agency calculated retroactively and said, oh, and we're applying this change to last month, which means you owe us this many dollars. So that's
I haven't worked through this myself, but presumably you could say a divorce decree that has yet to be interpreted by the agency, or that has yet to be entered.
Well, that's a slightly different question. I don't think that's quite retroactivity versus prospectivity. I think that's the question on whether the rule has immediate effect or not. So you could imagine the agency implementing a rule that doesn't have immediate effect, that says from July 1, 2016, any divorce decrees entered into after that date, this is how we're going to interpret them. And that doesn't have any change on current benefits prospectively or retroactively. But that's obviously not what this case is.
Thank you.
Thank you.